caused Ms. Madsen to be to have a competency evaluation to ensure that Ms. Madsen is what could be adjudicated on this matter. We did receive the results of that competency evaluation. And that competency evaluation was delivered on December 24th, indicating that Ms. Madsen does not have the meet the criteria to be considered competent to stand trial, that she could not be of effective assistance to her attorney. It also indicates that she does not appear to be have the substantial possibility of attaining competence in the foreseeable future. With regard to harm to self or others, the evaluator did not really render a decision in that aspect of the case. Mr. Altum, is the city in receipt of that competency evaluation?
Yes, Your Honor.
Thank you. And Mr. Puentes, you're in receipt of that evaluation as well?
Yes, Your Honor.
Mr. Puentes, you indicated you would like to address the court, please.
Your Honor, this is trespassing at the row. We have a situation where the young lady, my client, unfortunately, there was something to do with prescription drugs that were mismanaged by a mental health professional. And eventually my client deteriorated, and now she finds herself in a situation where she can't care for herself. The family is extremely concerned. They're frustrated, as you might imagine. Oftentimes when we have these misdemeanor cases, the family is hoping that this is the one case that's going to basically solve 3-4 years of dysfunctional behavior. So they were hoping that through this case that there could be court intervention, and that we could finally stop this cycle where they're worried sick about her and she's on the streets and she can't care for herself. I've tried to explain to them that unfortunately there's a huge void in the criminal justice system when it comes to mental health, especially on a misdemeanor. We kind of predicted that she would be found incompetent. I've tried to explain to them, and I think we're on the same page, but I've tried to explain to them that the court's hands are tied. You can ask that the jail and or the DA's office pursue a legal 2000. This type of charge, unfortunately, in my experience, because it's a trespassing, not to be a pessimist, but I don't see what they'd like to see the court do is order her to Lakes Crossing and medication and this and that, and it just doesn't happen on a misdemeanor. And again, your hands are tied. So they wanted to be here. She has tremendous family support. They showed up to court when we were in court a few weeks ago on the trespassing at the El Dorado. And I thought the best way, they wanted to be involved in today's proceeding. They're not really victims for purposes of our case. This is a trespassing at the El Dorado, but certainly they care for her and they wanted to at least hear what may or may not happen on this case. Thank you.
Thank you, Mr. Puentes. I appreciate you laying a foundation for everything this morning and laying some context as well with regard to Ms. Madsen's current condition. You know, and Mr. Altum knows as well as I, that I'm limited in what I can do. We're a limited jurisdiction court. We're not a general jurisdiction court. And therefore, I do not have the capacity to order Ms. Madsen to be civilly committed. That is not within my statutory jurisdiction. That jurisdiction lies with the district court. That's a general jurisdiction court, and it lies with the DA's office and the public defender's office pursuing that civil commitment. I have no such authority. So we're limited in terms of what we can do. And I got to tell you, with regard to the ability to have Ms. Madsen civilly committed, as Mr. Puente said, on a trespassing charge is frankly not likely. I've never seen it happen in my tenure as prosecution, as defense, or as a judge, because space is limited, and Lakes Crossing limits those who are civilly committed typically to felonies or gross misdemeanors, and very rarely do they place someone under civil involuntary commitment for a misdemeanor crime. And the only time I've seen that happen in the past is when they're violent crimes, and then they will take the unique position to civilly commit someone. But again, that's not within this court's jurisdiction. That would have to be a higher court in the district court. So we're left here with a difficult situation that this court finds itself in from time to time, where we have a person that is in desperate need of mental health treatment. that mental health treatment probably needs to be required or ordered or forced upon Miss Madsen. And yet we're faced with a misdemeanor crime where the judge presiding has no such authority. And so we're stuck. We're stuck until Miss Madsen or the family, and the family can pursue civil commitment as well. I want you to know that that's a part of the statutory scheme. You would have to work with a medical professional in order to pursue that civil commitment for Miss Madsen's benefit. Perhaps a guardianship is the way to go. I can't offer any legal advice, but I think we all know that we're all stuck in this particular position. Therefore, I'm going to ask the city what the city would like to do, given the fact that we have a competency evaluation that finds Miss Madsen not competent to proceed. And therefore, this we're all bound by statute under these circumstances. So, Mr. Altum, how would the city like to proceed?
Thank you, Your Honor. Based on the competency evaluation, the city is going to be, it's necessary that we dismiss without prejudice at this time. There are, as Your Honor stated, there's none of us here, that Mr. Puentes, Your Honor, myself, none of us are unsympathetic to the situation. It can be extremely frustrating, but as far as being a city attorney, I can't do anything, and I'm unallowed by law to go forward on this case.
Yeah, that's exactly right. And I want the family members to understand that Mr. Altum, now faced with a competency evaluation finding Ms. Madsen not competent to proceed to trial, he's obligated to do what he's just done, which is dismiss the charge without prejudice. That does leave the case closed. And Ms. Madsen is going to be released unless she's held on other charges that this court is not aware of. And so I guess from this point on, family, I'm addressing you. You're bearing the difficult burden of trying to care for Miss Madsen, stand in her best interest, where she probably does not want any of that care or to be medicated in any certain way. And so you're in this untenable, difficult situation with your family member who you love and are unable to do much of anything for Miss Madsen. You know, it's unfortunate that our system doesn't allow for anything to happen at this level and wait for either a more serious crime, such as a gross or a felony, to accommodate this, or conditions have to get so bad that either someone assumes guardianship over the person, conservatorship over the person, or pursues a involuntary civil commitment under that statutory scheme. So we are where we are. The case will be dismissed without prejudice pursuant to the city's motion, and this matter will be closed and Ms. Madsen will be released. Thank you, everyone.